panga mtunzi tiende pamozi tonse a Zambia mtima umozi chikondi chatu palibe kusiana ndife amozi tieni tipange ziko latu.
Good day, Zambia, and welcome to the Zambian Files. The Zambian Supreme Court has just delivered another masterclass in untangling Zambia's endless legal spaghetti, this time involving jailed politician Ronald Chitotela and the mysterious vanishing house at State Lodge. Remember this one? The Economic and Financial Crimes Court, EFCC, had proudly marched in, chest out, declaring that Chitotela's property was now theirs to seize because, well, proceeds of crime. But the Supreme Court has just slammed the brakes, saying the EFCC was never even supposed to be driving this bus in the first place. Chief Justice Mumba Malila, flanked by Justices Roida Kaoma and Fulgency Chisanga, didn't just poke holes in the EFCC ruling. They shredded it, saying the case was wrongly parked at the EFCC's doorstep. In their judgment, the EFCC simply lacked jurisdiction. Translation? They were flexing muscles in the wrong gym. The case now goes back to the High Court, but this time not through the EFCC's division. Why? Because according to the Supreme Court, this was never about economic and financial crimes. It was about something far more fundamental: Chitotela's human rights and the presumption of innocence. And here is where it gets juicy. The man was basically shouting from the rooftops that the Anti-Corruption Commission, ACC, jumped the gun, grabbing his house without first proving he was guilty. The classic "we'll take it first, you explain later" approach. Now, before we start romanticizing Chitotela as a freedom fighter, let's not forget this is the same former Minister of Housing and Infrastructure Development who has had more corruption clouds following him than a weather system over the Copper Belt. But even if you dislike the man, the principle here matters. If courts allow property seizures without due process, then tomorrow it could be your little farm, your house in Charleston, or your grandmother's plot in Mongo that suddenly becomes suspected proceeds of crime. The Supreme Court wasn't playing games. They made it clear the irregularity was caused by the judiciary itself misclassifying the case. In fact, they were so blunt that they even ordered each party to pay their own legal costs, probably to remind everyone that the circus was staged by the system itself, not the litigants. And so, here we are. The house in State Lodge is back in legal limbo. Chitotela gets a small legal victory, and Zambia gets yet another reminder that the fight against corruption must be fought with the Constitution in one hand, not a shortcut in the other. Because when shortcuts become the norm, the road doesn't lead to justice. It leads straight into chaos. So the question now is this a turning point for Zambia's judiciary finally asserting its independence, or just another temporary reprieve for a politician who knows his way around the courts like a fish knows water? Either way, one thing is clear. If the Anti-Corruption Commission wants to nail him, they are going to have to prove it the old-fashioned way, in a proper trial, with proper evidence, in the proper court, and that, ladies and gentlemen, is exactly how it should be. Ladies and gentlemen, do you think this ruling strengthens Zambia's justice system or weakens the fight against corruption? Comment below, and don't forget, subscribe to the Zambian Files for more unfiltered, sharp, and fearless breakdowns of the stories shaping Zambia.